Immigration updates. Emily, what do we have today to discuss?
Yeah, we had an interesting turn of events on a Fox News interview from President Trump earlier this week, where he almost sounded like he was in favor of H-1B visas. We'll talk about that. What did he say? Should we put much stock in that? And we want to talk more about this Project Firewall from the Department of Labor and how they're coordinating with USCIS using data analytics to root out fraud in the H-1B visa program. We also are getting a lot of questions right now about changing status to B2 for those on an H-1B that are dealing with a job loss situation, and how exactly the $100,000 Trump fee is incorporated into that, whether it's triggered. And then lastly, for F1 students traveling when they have OPT, is it safe to travel if they have any kind of unpaid work history during their initial 1 year OPT time?
Emily, with regards to Trump saying the things, so that's definitely has to be a little bit better news, definitely compared to what continuously we're getting statement from the Trump administration. But with Stephen Miller as the immigration advisor and who is actually taking charge of what's going on, what do you see in the coming in the next 3 years? How Trump administration did he flip 360 degrees over and then saying that now we're going to see good news for the H1B people, or is it going to be the same stance what it was in the past 1 year?
Yeah, I don't think that he's going to change anything in terms of making H-1Bs easier to get or eliminating the $100,000 fee that he put into place. I mean, I chalk this up to when he said that we should put green cards, staple green cards to the diplomas of F1 student visa holders once they graduate with a master's degree. Obviously, that didn't go anywhere. You know, it's nice to see that he realizes that the H-1B does provide a important tool for the American economy. It provides us with the necessary talent when we don't have that talent, when we need training to get that talent. He talked about the battery plant with people from South Korea who were here lawfully doing their jobs to get that plant up and running, training US workers, and ICE came in and detained them all and sent them all back home. And how we really need to actually allow people to come into the US to be able to train US workers in these new and emerging technologies and in manufacturing things that we don't have a history of in our economy. So that was nice to see. But as you mentioned, Stephen Miller is still the person in his ear that's actually pushing forward with policy. And so I don't see any positive coming from those comments. I think he's still moving ahead with the $100,000 fee. I don't think there are any plans to make the H-1B any easier for anyone. And they are likely to increase requests for evidence, increase fraud detection, just based on everything else that they've already been doing since January.
Just because of this statement, if you want to make any travel plans where you think so that U.S. consulate is going to welcome you, give the H1B stamping and H4 stampings. Don't believe in that at this point of time, guys. So still take it with a pinch of salt, especially if you're planning to travel. I would cautiously advise you not to. If it is really emergency, then I want you to get an advice from the immigration lawyer to make sure that everything is going okay before you can make a travel plans. In the coming years, as Emily has pointed out, it's going to be a little bit tougher, definitely. It's not going to be easier just because of the statement. Emily, we have seen a lot of fraud, definitely. Yeah, I would say a lot of fraud, but there's definitely a fraud in H1B. I would say about 5% of them we see the people who file in-house projects, the people who file where there is no job and they file from PO boxes at H1B as if that they're working. Hundreds of people are working from PO box. Now, this project firewall seems to be that they're using different kinds of softwares to detect what is fraud, where is fraud. How do you think so this is going to impact? The rumor is that there are 175 companies under the radar at this point of time. Mostly, I'm assuming that these are the consulting companies that filed fraudulent H1Bs. Emily, what do you say?
Yeah, I think that's just the beginning. I think we're going to see way more of that. I mean, if you think about um, a lot of employment-based immigration is online filing. So we have LCAs for H1Bs that are filed online. We have the H1B registration, which is filed online. We have PERM filed online. We have prevailing wages filed online. And some employers do use the online filing of the I-129 form, small companies and that sort of thing, although it's not used a lot. But because you have all of these databases gathering information, it makes it much easier for all the different agencies involved to share that information and cross-reference it and see if what's stated on one side is actually happening, on top of the site visit program where they're targeting certain types of companies that they know have a higher rate of fraud. So I think this is just the beginning. We've definitely seen in requests for evidence, notice of intent to deny, notice of intent to revoke, where they will look back at prior H1Bs, look at what the LCA said in that prior H1B, look at the recent pay statements, look at the W-2s and say, hey, 3 years ago, you said you were going to pay this person $100,000 a year. We see that you've only been paying $90,000 per year. Therefore, we intend to deny because we think you're not in alignment with the H1B program LCA regulations. And rightly so, they should be doing that if that's the case. It is good that they are looking at these companies and rooting out that fraud. So the legitimate companies, the legitimate employees, one would hope would have an easier time. I think the hard thing is when you have these government databases and they're using AI and using these programs, it tends to cast a very wide net that makes legitimate companies jump through more hoops than what are necessary, slows everything down. You have more RFEs, everything takes longer. So that's the downside of it from what I expect to see. And I do think there's going to be more coming.
Emily, we have advised people that for the people who are on H1B, who loses a job, we have advised they can move to change the status to B2. You definitely promoted that. We definitely also give advice with regards to the compelling circumstances EAD. We also told that you can always go back to your home country and come back into United States. We also told if there is H4 option, please move to H4 now. Also, if you move to F1 if you need it to. Now, with the $100,000 fees, what are the changes that you will advise the people? What previously you advised something, do you intend to change any of your advices right now?
Yeah, I think the big one that you mentioned is the compelling circumstances EAD is very unattractive when you have this $100,000 fee. Because once you get onto the compelling circumstances EAD, you are no longer in a non-immigrant status, which means that once you do get a valid H-1B job offer and you're ready to move back to H-1B status, you can't just file a change of status from compelling circumstances EAD to H-1B. That only works if you're in a non-immigrant status, like a B2 or an F1. So for compelling circumstances EAD to get back to H-1B, they have to leave the country, which means the company is going to be filing a consular processing H-1B request, which means the $100,000 fee is going to be triggered. So once you get on that compelling circumstances EAD, there's really no coming back until the $100,000 fee goes away. I do still think probably the B2, unless of course you have an H4 option or something like that, but the B2 is still a good option and probably is the best option, because once you get on B2, when you do have that new job offer and you need to get back to H1B, you can file it as a change of status while you stay in the US, which means that the $100,000 fee does not apply when you're getting back to H1B. So we are still routinely filing change of status to B2 for people who are in that situation. We're currently filing change of status back to H1B for a lot of people who had to file B2s during the government shutdown because they couldn't get their transfer filed in time, and those are being processed normally. So I still think that's a good option.
Yeah, and people are always asking questions. They do come to the daily Zoom calls and ask questions. Hey, can I move back from B2 to H1B without going through the consular processing? Absolutely, you don't have to go through the consular processing. You can change the status within United States, and you're not subject to $100,000 fees. Of course, the same thing is applicable for H4. If somebody has an H4 or a B2, definitely I would prefer a H4 option would be much better. Emily, Right now, students are traveling. This is a Christmas time. They want to travel. What do you speak about people who are on OPT and STEM extension and they want to travel outside the country and coming back? What are the precautions that they need to be worried about? You have consistently said that on the OPT, they are allowed to do an internship, unpaid internship. However, we have seen some of them getting deported in Chicago airport and also in Abu Dhabi airport. They were not turned back into because they worked as a unpaid internship in the OPT period. So if somebody worked without pay in the OPT period, should they be concerned about it?
I think they should. Although, if the unpaid internship does meet all of the Labor Department requirements to qualify as an unpaid internship, it does count as an employment for the initial 1 year of OPT time. There are a lot of people who did unpaid internships that maybe don't meet those qualifications. And those CBP officers are assuming that if you're doing an unpaid internship, that is basically being unemployed. And so they're thinking that you've exceeded the 150-day unemployment limit or the 90-day unemployment limit during your OPT time, and therefore you are out of F1 status, no longer authorized to come back into the US. So it is very risky for someone who has that unpaid time in their OPT history to travel if it has exceeded those unemployment limits.
Let's go to
Um,
questions, Emily, unless you have
sure.
something.
Hope we can go ahead to
Um,
questions.
um, Sul from YouTube is asking the questions. He has spent 8 months in India, but he was actually remotely working in India at that point of time when he visited India. Does it count towards the 6 years of the H1B, or he can take that off from the 6 years of H1B? He has worked, he got paid. The answer to the question is he doesn't need this 8 months will not be counted toward the H1B period. It will be counted as it will be excluded from the eight in the 6 years though. If you're working in India, you're actually technically you're an Indian national, you can work in India, not a problem. So you can take that. It will not that 8 months will not be counted towards the 6 years.
Ricky says, if the H-1B wage increase rule comes into play, will it impact existing H-1B workers at the time of their renewal next year? Will the new wages have to be forced on that LCA? Yes. So when they issue the final regulation that changes how they calculate the prevailing wages, um, the government will go through all of the prevailing wages that they've already calculated, and most likely beginning on July 1st with the next year's wage calculations, they will implement those new calculations. And every single LCA filed after that date will be subject to the new prevailing wages, assuming you're using the OFLC online wage library to get your prevailing wage. There are other wage options like private wage surveys. But yeah, so it will impact existing H-1B workers when they're filing their next extension, or when they're filing a transfer, when they're filing an amendment, anything that requires a new LCA after most likely July 1st, 2026 is going to need to use that new prevailing wage.
Rick is asking the question that he's first time going for the H1B stamping. He got the H1B approval in 2023. What precautions he should take? Well, instead of precautions, I would say that you need to have a plan B. If you don't get the stamping, what's going to happen with your car, your house, your family here? That you need to look into it. The other thing is that if you don't get a H1B stamping, you can always come back in a company B. Right now, the company B option won't be there because if any other H1B is being filed while you're outside the country, the $100,000 will be applicable. Definitely, I would recommend strongly not to leave unless it's a real urgent. And if it's a real urgent, make sure that the pay stubs are there. You have all the W-2 forms. The LCA is complying with the location where the LCA, wherever the LCA location is, you're working at that particular location. And if you are working for an end client through a consulting company, get a end client letter available for you when you go for stamping. These are the things that you need to take care of. Take the income tax returns and bank statement to support your pay stubs.
BG says, I was laid off on H1 and now on a pending B2. Do you suggest a change of status or consular processing? And should I include a B2 withdrawal letter while filing for my premium H1 transfer? Definitely not consular processing, because that is going to cause the $100,000 filing fee to be triggered. So you definitely need to file it as a change of status from pending B2 back to H1B. And you should not include a withdrawal letter for that B2. What if you ask your B2 to be withdrawn and your H1B gets denied? Now you have nothing. That is a huge risk. Do not do that. You don't need to withdraw the B2 until after your H1B gets approved. So be very careful with that.
Um, Second. Shriva has this question that if the adjustment of status has been denied and I want to move from AOS EAD to H1B, is the $100,000 applicable? From AOS EAD to H1B, you have to go through the consular processing. If you go to the consular processing, the $100,000 fees is applicable. So you need to, that $100,000 will be applicable if you get the GC denied, you want to move back to H1B.
Bubakar says, what is the travel risk for H1B holders with a valid visa stamp expiring in 2027? No change in role, job, or employer. It is less of a risk. There's still risk. Number one, I would say, what is your employer's record, immigration history? Is it a strong company? What kind of company is it? What is your role? Are you directly working in-house for a company? Are you working third-party placement through a staffing company? There are certain H-1B filings that have more risk than others. So that's number one. And so assuming everything's great, you're working for a household name company, everybody knows that company, you're like the top person in that role, and it's very clear that you're meeting all of the requirements. The biggest risk for people that have the valid visa is the random Trump uncertainty. I mean, you saw the chaos that ensued when Trump got ready to announce the $100,000 proclamation. Nobody knew who it applied to. Everybody who was outside the country when that happened immediately started trying to make plans to come back before the Sunday midnight deadline, because he made it sound like everybody was going to be having to pay this $100,000 fee or they'll be stuck outside the country. Turns out that's not the case. However, it was very scary for those people who were outside the country. So you don't want to get stuck outside the country when there's any new travel ban that comes up or any new kind of proclamation like that. That's the big risk. And those are things that the Trump administration routinely did during the previous administration. And it's clear that they do that again under the current administration, just with this $100,000 fee as an example.
A question from Jugal is asking very interesting question. And this question is coming from a couple of other people also, Emily, and I want you also, your input also, is that do we need to carry the original H1B approval? Do we need to carry the green card approval, a green card with us wherever we travel? Especially with ICE, ICE is on the streets. My advice, Emily, please correct me if I'm wrong, is that no, you don't have to, as long as you have a copy of it, though. We haven't had any reports where they have asked the IDs or they have picked up the legal people and put it in the detention at this point of time when they've been going on the streets. We haven't seen those kind of things happening, though. Now, they do have the ICE has a facility where if you provide your copy of your H1B or copy of your green card, though, they can verify that whether that information is correct or not. They're checking the eye scanning thing where they can detect whether you are the right person or not. So I don't see that you need to carry the H1B or the non-immigrant status original or the green card approval. What do you say, Emily?
Yeah, I agree with you. I've not heard any reports of people who are green card holders or H-1B holders who didn't have their document on them and they were detained because of it. And I don't think I've seen anyone have to have an original to prove what their status is, but I would definitely keep a copy of it, take a picture of it, have that on your phone and have it handy, because as you mentioned, they are able to use biometrics and verify identity with all the technology that they have right now. Mahir
Still,
says, I'm currently on B2 pending and received a job offer. My new employer is supportive and they're going to try their best to get the H1B transfer done. Are there any likely complications involved? Well, just in any H1B, you've got to make sure that the job that they're offering qualifies as a specialty occupation. They have the LCA, they choose the proper SOC code, they choose the proper wage level, that you have the education needed for that job, you have an education evaluation if you didn't have your degree from the US. So those are just the basics. Now, when I'm filing a change of status from pending B2 because it's not yet approved, I will go back to the day that the B2 was filed and provide supporting evidence to show that you are properly maintaining status up to the time of the B2 filing and that you've maintained your status since the B2 filing up till the time of the H1B filing. And with that, I don't think I've ever had any request for evidence on those H1Bs regarding the status. The few times I've seen a request for evidence on those cases, they have very rarely said they want to see the B2 approval before they'll approve the H1B. But once we reply back with all of the documentation showing proper maintenance of status going back to the loss of the previous H1B all the way up to the filing of the new H1B, we've been successful to get those approved.
Step Climax has this question. My wife, who's an H1B, got her H1B approved before September 21st of 2025. That's before the $100,000 proclamation. But that was a council processing. Is the $100,000 applicable? Since the H1B has been filed before September, before the proclamation, the $100,000 is not applicable. She can go for stamping outside the country, not a problem. That $100,000 is not applicable. But actually, she has an option. I mean, if she's in United States, though, since you're an L1, either she has some other non-immigrant visa or she can even come on L2 visa. She can change the status in United States, even though she has H1B approval. She doesn't have to go for stamping. The company can file a change of status within United States. Either they file the change of status within United States or she goes to the consulate. Either way, the $100,000 is not applicable because the H1B was filed before the proclamation.
Tech with Jag says, you suggest to file a concurrent self-sponsored H1B under the current administration, or will it trigger a site visit, which might not be worth it under this administration? I'm filing them. I'm getting approvals of them. The ones I have filed, as far as I know, no one's had a site visit happen. I do let them know that if they are running this business out of their home and they use that as the company address and the work location address, a site visit can happen at their home. So if they want to avoid that, maybe they could consider getting an office space and using that as the company address. Up until this point, just from my personal experience, I've not really had people have difficulties with site visits for those self-employment or the entrepreneur type H1Bs. I think part of that is the fact that they limit the approvals to only 18 months. So when it's time to file that next extension, we'll probably start to see more scrutiny and them wanting to verify that you've been doing what you said you were going to be doing and that the job is legitimate and the business is operating and running.
Emily, do they need to be fearful if they are doing a genuine self-employment and everything is fine? I don't think so. This administration is anti new entrepreneurs. Are
Yeah, I agree with you. I think what I recommend people who are in the entrepreneur H1B is don't file H1Bs for your company. Don't employ other H1B holders because once you start signing paperwork for someone else's H1B, that is what gets people into problems with their own cases in the future. And I definitely have seen that.
but if they are just the company is filing only for the entrepreneur, you don't see that as a discouragement from this current administration. Is that right, Emily?
No, I don't think they're being targeted in any way for site visits or any increased enforcement at this
N-
time.
Not that I'm a fan of Trump administration, but in a way that they actually are promoting the entrepreneurship H1Bs at this point of time. So we don't see that administration is trying to make it hard for entrepreneurs to establish companies and progress in the companies.
Sandeep says, I have an approved I-140 and I'm currently working on H1B. If I convert myself to H4 and stay in the US on H4, can I change back to H1B in the future, even if my H1B has been expired? Yes, you can. Once you have that I-140 approved, the 6-year limit on H1B no longer applies. So you can convert back to H1B at any time without going through the lottery again. You're not subject to the cap. The most important thing to be aware of is that once your priority date of that I-140 has been current for 1 full year under the final action date, then you're cut off. You can't at that point change back to H1B. So you need to monitor the priority date of that I-140. As long as it's not current, yes, you can change back to H1B anytime in the future.
Can the debt collection affect the adjustment of status application? Sometimes we haven't seen it at all that it's going to affect the adjustment of status, especially for the employment based. However, there may be some new regulations that may pop up soon, and they may define more if somebody is not having enough financial support to stay in United States. We're also expecting something with related to the health ground to see if they would become if they are a potential burden in United States. So definitely there are some things that are coming up, but as of now, we haven't seen any problem. If there is some collection that is still pending and you file the 485 application.
Praveen says I filed my citizenship on October 20th. Any changes in the applications or otherwise, like this good neighbor certificate for these new applications? Any travel concerns I should be careful of? So the only change that they've implemented is expanding the list of questions that they can ask and the number of questions for the, your knowledge of U.S. history and government and those sorts of things. I don't think I've ever had a employment-based client fail that test. I mean, if you've studied for a master's degree and passed your finals there, I'm pretty sure you can pass the citizenship exam even with these extra questions on it. I have not seen any implementation of this good neighbor certificate where they're, asking around your friends and neighbors to see if you're a good person or not. And as far as travel, just make sure that you are not taking long trips that are going to impact your continuous presence and continuous residence in the country to qualify for citizenship.
Emily, I want your discussion on the Sumit Singh question. Can a H1B holder serve as a board of director for a non-government organization? I'm assuming that it's a non-profit organization, Emily. And if it's a non-profit organization, if he's serving as a board of director, uh, and if it's truly voluntary basis, not expecting any future money from that particular organization, do you see any problem with that?
I think if this is along the lines of kind of a charitable volunteering situation, I don't see any problem with that. It's just like volunteering for the Red Cross to hand out water during a hurricane or something like that. I don't think that's considered unauthorized employment. So I'm not seeing a problem with that. But I think that's different than serving on the board of directors of a for-profit company where you're actually advising the company and much more involved. I don't know your thoughts on that.
Yeah, I agree with you, Emily. If you are a member of any temple or any church or any masjid, these are religious organizations. People don't expect to get paid in those organizations. They don't expect any monetary benefit from those. And if you're serving in some uh, like language, for example, Telugu cultural organizations, Hindi cultural organizations, Maharashtrian cultural organizations, I don't see that any problem. Never have seen any USCIS giving any problem if you're serving in some of those things. We've never, and some of them are like running association, tree planting associations, yoga associations. I don't see any problem in that.
Joe says, my son had aged out after the green card. If I sponsor him on the family-based visa, can I retain his priority date from when he was on H4? Unfortunately, no. So assuming that you were sponsored under the employment-based category and you received your green card, but your son didn't because he aged out, when you file the I-130 under the family-based category for your son, for a son of a green card holder, the family-based category is completely separate. It's a brand new priority date. You basically start at the back of the line for that process.
One second. Questions are asked with regarding to AOS EAD, whether the person can move from AOS EAD to H1B. Is $100,000 applicable? Here's the rule though, whenever it's a council processing, guys, it is $100,000. Since adjustment of status is not a non-immigrant status, you can't move from adjustment of status to H1B. So since you're moving to a adjustment of status to H1B, you will have to go to the consular processing. Since you have to go to the consular processing, you will be subject to the $100,000 fees.
Sarmad says, what is your take on the December visa bulletin with regards to EB2 rest of world? Will the final action date move to catch up to the date for filing chart by October 2026? And that's definitely the goal of having the two charts. The final action date is what we can approve today. The filing date is what we think we can accept over the next 12 months. And so that puts you to October 1st, 2026. So the filing date is a prediction of where the final action date should be by then, by the end of the fiscal year. And I think they have, in many cases, been correct in those assessments, although sometimes the filing date does change throughout the year. So we'll have to see if they make any adjustments one way or another on that.
Anush has some interesting questions. I would put two of those questions. Can a H1B participant invest in as a capitalist? The answer is yes. The H1B person can invest. Can the person be a venture capitalist? Venture capitalist is a little bit very confusing because the person cannot be involved in the management of the company, though. So if the investor is involving in management of the company, though, then definitely that is not allowed. If you're just investing and you're going to make the profit when the company does the profit, then absolutely not a problem. You have another question. Can a H1B person build a product and take it to market for investors? The answer may be no, but there are ways where you can have a self-employment where we call it as entrepreneur H1Bs. Now, when you're working for company A, you can either form your own company and become an entrepreneur yourself and file a H1B for 18 months. But there is another process where if you're working for company A, you can open a company B and you can work with company B on a concurrent basis. That means that you're not working on a full-time basis to company B. Your full-time is still company A, but on a part-time, you're working for company B. In that way, you can then build a product and you can take to the investors and make $1 billion if you want to. Definitely you are allowed to. So that would be a better thing. But if to form a different company and do a concurrent H1B would be much better for you.
Ganesh says, when I asked my employer to upgrade my H1 extension to premium processing, they're saying the receipt notice is missing. What options do I have? My H1 is expiring December 15th. So they can't get the receipt notice, but they can get the receipt number. And that's all they need to do the premium upgrade. They just need to include that number in the I-907 form. If the H1B was filed before we switched to the electronic filing fees, they may be able to get the receipt number off the back of the check that was cashed, although that's less likely nowadays. But either the company or the attorney can call USCIS and they will get the receipt number over the phone. Calling them is a big mess. It's really, really hard to talk to a live person. Doesn't matter what you say nowadays, you'll go through that phone tree. It's very, very frustrating. So I use the live agent chat with Emma on their website and have very good success in getting missing receipt numbers through that process. But it has to be the company or the company's attorney only. You cannot do it.
Question, Abhishek Trivedi is asking, if I file a H1B to B2 and if it's been denied, how much time do you have to leave the country? We haven't seen B2 denials. Very rarely. I mean, I haven't seen it after the hundreds of the cases that we filed, maybe one, which I haven't seen it. But if by any chance the B2 gets denied, you can leave the country within 2 weeks after the B2 is denied.
Mohammed says, I have a scheduled H1B visa interview in Canada for March 2026. It was made before the rule changed regarding only going in your home country. Am I still eligible to attend this interview? So according to the rules, yes, because you scheduled it before they made that change, you're supposed to be able to keep that interview. However, I have had
Yeah.
reports from other attorneys that it does not go well. So I would not recommend it, even though you do technically qualify it for it under the rules.
Yeah, I have a lot of people stuck outside the country, Emily, and they couldn't come
Yeah.
back.
Me Too says H1 has been approved till 2027, while the H4 and H4 EAD were in progress. I went to India, got the H4 stamped, and came back in. But now got the H4 EAD, but only till 2026, not till 2027. Do we need to file for the H4 EAD again? Yes, you do. I don't know if it was issued as a typo. I'm not sure where that 2026 date came from, but you will spend so much time and energy and effort to try to get a typo corrected and get the card back versus just filing it again. So I always say just file it again, pay the fee, get it over with, because even if it was a typo, even if it was an error, you have to send the card in, and then they take months to send it back to you if they ever do. I've got people that have been stuck waiting forever and just ended up refiling after waiting several months. So it just delayed it even further.
Previously on H1B, now on F1, if the candidate is subject to pay $100,000 if they transfer back to H1B. This question is from Ajay Chaurashia from Facebook. The answer is no. Whenever a person is moving from F1 to H1B, whether they are moving under the new quota or probably they already have a H1B previously, this $100,000 is not applicable.
Rafi says, what will the 2026 H1B process be like? It's already December now. We're not sure about the wage-based H1B, not sure about the $100,000. There's court cases in progress. Yeah, it definitely makes it very hard for companies and their employees to plan. What we can say is we anticipate that H1Bs filed as a change of status are not subject to the $100,000 fee, so you don't have to worry about that. We don't know what the lottery selection will look like, if it's going to be based on the wage level or not. But assuming that it will be, if you can get a job offer that qualifies as at a higher wage level and give yourself some extra chances in the lottery, that's certainly a good idea to look into. And we don't know what the prevailing wage will be. As we talked about earlier, there's going to be a regulation to change how that's calculated. So yeah, all we can do is plan with the information that we have and see what happens as these rules change constantly.
Premium from YouTube has this question that because of some medical conditions, a person had to stay 7 months outside the country, and then are they now eligible for filing the N400? Yes, but I definitely want you to go through a lawyer. Normally, 98% of the cases for the N400, I tell go file yourself. But when you have more than 6 months outside the country, I strongly recommend you have a lawyer file your B2 application. There are a lot of documents that you need to supplement, lease agreements, income tax returns, and all those things you need to carry it with you when you go for the interview, and should have a good explanation why you stayed more than 6 months when you go for the citizenship interview.
Sudarshan says, does the $100,000 fee apply for people who are in AOS using the EAD and want to move back to H1B with the AOS still pending? It would if you don't have an already filed and approved H1B petition that was from before September 21st. So if maybe your previous H1B has expired and you never renewed it, or you're changing employers, the only way to convert from AOS back to H1B is through consular processing, which will trigger that $100,000 fee.
Abhishek Trivedi is asking this question. The I-140 is approved. What are the chances for the J1 to be approved in the consular processing? That means they go for the stamping. If you are in the country, I would recommend to change the status within the United States. Similar, because you have a higher chance of getting denial in the consular processing. A similar question came from another gentleman where the person moved from H4 to F1 in United States, and now the lady wants to go to her home country to get the F1 stamped. It's becoming very tough to get the F1 stamped when you go outside the country. So even though you got the F1 approved with the USCIS, the consulate there will look into whether your intention is to return back. So definitely it's becoming very tough. I would recommend that you do not travel. Or if you travel, come back on H4. Sorry, go ahead, Emily.
Soumya says the amendment was filed for a client change after September 21st. It's approved while I'm in the US. Is it safe to travel for visa stamping to India? No, absolutely not. We don't recommend going for stamping right now. We are seeing a lot of people stuck with 221Gs, getting delayed, even though you got the amendment approved. It has nothing to do with the $100,000 fee. If you are planning to travel and you need a visa stamp, we have been recommending against it since January when Trump took office.
Rebecca Jones has this question. Recently H1B extension has already been approved. So when you're telling H1B extension is approved, it's been approved along with the I-797A, which has an I-94 at the bottom. Is the $100,000 is applicable? The answer is no. Since it's already approved extension with the I-94, $100,000 is not applicable. You can go for stamping. Now, I'm not encouraging you to go for stamping, but I'm just telling that the $100,000 is not applicable.
IT Guy 007 says, I downgraded from EB2 to EB3 and filed the AOS I-140 485 concurrently. How long do I need to wait if I need to switch employers? Does my I-140 need to be approved for more than 6 months to switch? No, it does not. So if you had not filed the 485, then we want your I-140 to be approved for 6 months so that you can use that I-140 for H1B extensions with new employers, and you still get to keep that priority date. But because you also filed the 485, we just want your I-140 to be approved, even if it was only for 1 day, but your 485 had to have been pending for at least 6 months. That makes you qualify for AC-21, so you can take the whole process with you to the new employer.
Good question. SGN 1989 has this question. He doesn't have the H1B stamping for a long period of time, and he wants to have a travel plan. Can he go outside? You can technically go. You can go and get the stamping, but it's becoming it's becoming very tough in the consulates. There are a lot of 221Gs issued. I want you to be, unless it's absolutely necessary, I do not want you to travel.
Rishi says, my spouse changed her status to F1 using a change of status. She's currently on F1 with OPT. Can she now travel to India using her I-20 and get the F1 visa stamped, or would it be difficult to get approved for F1? She should not travel to go for F1 stamping. It's going to be very difficult to get that visa approved. Number one, her program has already ended because she's got the OPT. Number two, she's married to an H1B holder who's in the US. It's going to be very difficult for her to establish ties to her home country, and that she intends to leave the US at the end of her OPT time. It's very likely that that F1 will be denied.
I just got the green card, and within 1 week after I got the green card, I'm laid off. Am I eligible for the unemployment benefits? Will it create any problem for the naturalization? Technically, you are eligible for unemployment benefits, but I'm a bit hesitant to, if I were you, I will probably not use that because I just got the green card. Within 1 week, you're applying for unemployment benefit. It may not sound that good. So I would, Karan Bashan, I would not, I would not take the chance of applying for unemployment benefits.
Deepak says, what is the minimum wage limit for an H-1B extension? There isn't one minimum wage for H-1Bs. Every single job has a prevailing wage, which is based on the occupation code assigned to those job duties, the wage level associated with the complexity of the position, whether there's supervising role, whether there's special skills involved, how much experience is needed, and the work location. So you have to know all three of those things, and then based on those three, there will be a set minimum prevailing wage that has to be paid for that role. But it's different for every single location, different for every single job. So there's not one number.
PT, she or he works for the healthcare industry, and is it okay to have the second employer fire a concurrently filed H1B on a part-time basis? Absolutely, you can have that. Not a problem. I see a lot of physical therapists, occupational therapists doing multiple jobs. In fact, my wife is a physical therapist. At one point of time, she had 8 employers at the same time. She was on call, of course. That physical therapists and occupational therapists, they do a lot of that thing. Nothing wrong with it. You can have the second company file a concurrent filed H1B.
SGN 1989 says, I'm with company A in the US, and if I get a new offer with company B willing to do my transfer, can I travel to India for stamping through company B? Does the $100,000 fee apply? The $100,000 fee does not apply to transfers. So once you get it approved, if you later travel and go for stamping, the $100,000 fee does not apply. Should you go for stamping right now? No. It is not the time to go for visa stamping for H-1B holders for F1. It is very anti-immigration across the board. Consular officers are told to find any reason to deny, find any reason to delay. There's a big risk for that. So unless there's a really important reason that you need to go, that you're willing to lose your career in the US over it, I don't think it's a good time to go for stamping.
And please have sympathy on these good officers in the consulate office, though. If they're giving more visas, this is what's happening with them. They're getting fired. And the good, decent officers, make sure that they don't get fired, guys. What are the chances for 221Gs for change of status from L1B to H1B or L2S to H1B? Well, it depends on a lot of different circumstances. As Emily is pointing out, the administration has given clear instructions to obstruct any H1Bs as much as possible to come back into the United States. So my question is that why can't you change the status in United States? When you're an L1, when you're L2, you can apply for the change of status, even though it's already been applied for the consular processing, as long as that H1B is applied before the proclamation, you can now change to change of status into H1B without any problem in United States instead of going to the consulate.
Nirvana says, I filed the 485 this week under EB1A with a 2016 priority date for India. How long do you think it can take to get the EAD and then the final approval? EADs can take anywhere from 3 months to 11 months. It's all across the board. I would say most of them, when they go to the National Benefits Center, are closer to that 3-month mark. In terms of 485 approval, it can be anywhere from 6 months to 2 years. Again, all across the board, no rhyme or reason to it.
Can I file a H4 EAD for my spouse if the perm is pending for more than 1 year? You must be in the 7th year H1B though to file the H4 EAD, not just the perm being pending for more than 1 year. You must also be on the 7th year H1B. Can I change my H1B consular processing to transfer within United States? This question is from Gopi. Yes, you can. If it's already been, I'm assuming that the H1B is already approved, the company has to still file a new H1B application to change it to transfer from within United States. We normally were recommending from the beginning never go for the consular processing, and now, of course, consular processing comes with a $100,000 bill, especially after the proclamation. So definitely, you can change within the United States instead of going to the consulate.
AP says, is there any hope for physicians to get an H-1B via the national interest exemption to avoid the $100,000 fee? There's been no discussion of a particular industry or type of position getting a blanket exemption, even though the proclamation allows for that. And as of this moment, I don't think anyone's received an exemption either. Just today, attorneys were reporting that they finally received email confirmation stating we received your national interest exemption request with no further details about what the process is or how long it's going to take or anything like that. So if you're going to go expect one, I think you're going to have to do it individually with your company versus waiting for some sort of blanket exemption that I don't think is going to happen, even though they said they could do that.
Abhilash has this question. He has an I-140 approved with company A. Now he wants to move to company B. I-140 is still active. Can he file an H-1B with company B? And later on, using company A's I-140 approval, can he extend the H-1B with company B? Can he? The answer is if the I-140 has been approved and not been withdrawn for a period of 180 days, yes, you can move to company B. You can extend the H1B with company B. You can move from company B to company C using company A's I-140 approval. You can move from company C to company D using company A's I-140 approval.
Ishan says, I've submitted a transfer of underlying basis in October 2025, but still not considered. Any suggestions? It's too early to expect them to process that and actually do the transfer, I think, since it was only a month. You could do a Freedom of Information Act request to get a copy of your file to see what category you're currently listed under and see if there's any reason for any delays. But it is very normal that you wouldn't hear anything back on it right away.
Okay.
Another question, which airport should be avoided for parents traveling to the US on B2 visa? I don't think there's any specific to that situation, but just in general, I'm not a fan of Chicago, Seattle, Boston, Abu Dhabi, Toronto, pre-flight inspection. I would avoid those.
My company is planning to send me as a department manager to India in support of the EB1C, written to engineering manager. My current position is L1A. Already applied for H1B renewal. I didn't understand the question, Sadanand. I'm sorry about that.
What changes are expected in the EB2 NIW and the EB1 rules or criteria? As I've heard, those are under investigation. So we know that there are in the regulatory agenda, they're planning on issuing some new regulations related to I-140s, and in that will likely include EB2 NIW and EB1. No one knows what those changes will be. I can only assume that they're going to be more strict. It's possible that maybe they will implement some of the updates in terms of technology to avoid talking about microfiche being submitted as evidence and that sort of thing, given the current technology that's out there. So that is a possibility. But with the Trump administration, I don't expect it to be easier for sure once those come out.
Shriva has this question. EB3 GC denied. Can a person change to B2 and then to H1B? The answer is no. You can't change from EB when you are not maintaining the non-immigrant status and the 485 gets denied. You can't move to B2. You can't move to H1B. You will have to go outside the country to move into any of that category. Hiren has this question. He has a concurrently filed H1B. If he loses the primary H1B, does he automatically go into the concurrent H1B as a primary H1B? We normally recommend an amendment for the concurrently filed H1B to make it as a primary, just so that in future you will not face any problem. That is a better strategy of doing business.
SP says H1B is valid until July 2026. Amendment was filed in June 2025 with an H4 EAD. Will the approval give a full 3-year term or only until July 2026 with an extension needed again? It depends on how that H1B amendment was filed. It's possible that it was filed just as an amendment, not requesting any extension of stay. If that's the case, then it will only be valid till July 2026. But if the employer selected amendment plus extension and paid the proper filing fee to get an extension, then it could be valid till 2028 based on whatever the 3-year term would be from June 2025 filing.
Question is asked by Nirvana that do people get interviewed under the employment-based green cards and the 485 process? We have seen approximately around 20 to 25% of the people do get the 485 interviews. It's going a little bit high. It's becoming almost like 25 to 30% right now. People do get the 485 interviews. Can the 485 interview happen even when the priority date is not current? This question comes very frequently to us. Yes, 485 interview can come in even when the priority date is not current.
Valero says, I got laid off on H1B, planning to do a change of status to H4. While the H4 is pending, can a new employer file an H1B change of status? Yes, that is possible. Just like filing from a pending B2 back to H1B, we would recommend premium processing on the H1B because you can't start work until the H1B actually gets approved since you're in pending H4.
Can a H1B 7th-year extension be filed along with the H4 EAD? The answer is yes. If you are eligible for the 7th-year extension, you can file the EAD along with the H1B and H4. Question with regards to Rahul Khanna is EB1A I-140 has been approved. H1B is valid until July 2026. Applied for AOS EAD. Should I file the H1 extension or just work on the H4 485 EAD? That's a very tough question. If everything is, I mean, there are some lawyers who recommend that you have to get the H1B. We normally don't recommend H1B, though EAD is a better safe. Right now, they are giving EADs for 5 years. So definitely that's a safer way. But there is a YouTube video we made. Is it worth moving to H1B or is it worth maintaining on the EAD? You may want to watch that one.
Mana Media says spouse in H1B laid off, currently in the 60-day grace period. What's the best option, changing from H1B to H4 or H1B to B2 if she can't find a job within 60 days? Assuming that your H1B job is relatively stable, I think it's better to file a change of status to H4 rather than B2, because with an H4 change of status, you can request the entire time that your H1B is approved for, which is generally going to be longer than what you could request in a B2, which is a maximum of only 6 months.
His husband, prior to date becomes current. Can the whole family file the 485? This question is coming from Soumya Roy. I'm assuming that you file as a dependent family based, dependent on the primary employment based. So if your husband is the primary and you are the dependent, yes, if the prior date becomes current for your husband, you and your husband both can file the 485. Absolutely not a problem.
Swapna says, I'm on H4 EAD. My company is willing to initiate the EB2 green card process. After that is initiated, can my company file an H1B? Will it be in the lottery system? Yes. So the EB2 process is completely separate from your current status. So you can be on H4, you can be on H1B, you can be in any different category outside the country. It doesn't matter. And you can move from H4 to H1B while your EB2 process is ongoing, because it is a very long drawn out process. And if you've never had an H1B before, yes, the H1B is going to be in the lottery, which is going to be opening in March 2026 for about a 2-week period where we do the electronic registrations.
Does the length of the stay of H4 matter when switching to H1B? If I'm staying for an year, can I switch to H4 from H4 to H1B? Absolutely doesn't matter whether the length of the stay on H4 is 1 month or whether it's 10 years on H4. Either way, it's not a problem. You can move to H1B. Absolutely not a problem at all.
All right, well, I think we're out of time for today. Thanks everyone for joining us. Please remember that we do have a free daily conference call on Zoom where you can join to also get your questions answered. You can go to rnlawgroup.com to get the details of that. And if you'd like more information about your specific situation, you can always set up a consultation with either of us or any of our attorneys here at Reddy Newman Brown by going to rnlawgroup.com.
Thank you very much for tuning.